what's the legal process for removing an unauthorized occupant? I have a case where a lady moved in her boyfriend, and the rental agreement clearly states that only certain people can occupy a unit.
Right.
He's not on there, obviously. And this particular person is a nuisance to other tenants, loud music, and she's gotten around it in a way in her mind by saying, well, he's not a tenant, he's a guest and a visitor, and I don't have any right to prevent a guest or a visitor, even though my other tenants say he's living there.
So the situation is we have a lease agreement and we have a provision in the lease agreement that in the eyes of the landlord is being breached. And it doesn't matter what provision it is. In your case, it's the provision relating to who is authorized to live in the unit and if there's anyone that wants to be added to the tenancy, what's the process to be added to the tenancy. You have a lease agreement that includes one tenant, yet you believe that there are two tenants living in the unit. I'm not going to say that it doesn't matter what the tenant says. Obviously, it does matter, especially if they admit it. But usually, somebody that does something wrong is not going to go say, oh, yeah, you're right, landlord. I have an unauthorized occupant. Of course. Uh, what matters is what evidence you have that a person is living in the unit unauthorized. If you have evidence to that effect, and that could be if you have any CCTV footage at the property or if you have any witnesses that tell you that they see the person there every day, or if you have information that that person parks at the property regularly, then the next step after you try to resolve things amicably with the tenant is to serve them with a notice. And that notice is titled Notice to Permanently Perform Covenant or Quit, basically telling the tenant Section 3 of your lease agreement dictates that there's only one authorized occupant, and you cite that provision. On or about so and so date and so time, landlord's agent name discovered that an additional individual is residing in the unit. This individual is seen daily, going in and out of the unit, going to work, coming back from work, parking at the property, and this was not approved by the landlord. You have 3 days to comply by doing the following: either remove the individual from the premises, or take the necessary steps to have him approved as a tenant. If they comply, the case is closed. If they don't comply, the next step is to terminate the tenancy. If your property is subject to AB 1482, the statewide rent control, you'll need to serve a follow-up notice to quit, meaning on this date, I served you a 3-day notice to perform or quit. It expired on this date. A day later, we still saw that the unauthorized occupant, meaning you didn't comply with the notice. Now you have 3 days to vacate the premises. Guess what? They're not going to vacate, right? So then the next step would be to file an eviction. The eviction process, I'll just briefly describe it. You file the complaint. The court issues a summons. You get a case number. A process server serves the tenant. Once the tenant is served, the tenant has 10 court days to respond. The best case scenario in evictions is if the tenant does not respond, what we called an uncontested case or a default case. If a default case happens, if the tenant fails to respond to the lawsuit, we ask the court to enter a default judgment. After the court enters a default judgment, we ask the court to issue a writ of possession. Anybody knows what's a writ of possession? One? Okay. Writ of
I
possession,
don't.
just to confirm, it's a document titled Writ of Possession. The way that I like to describe it to clients, it's just imagine that it's a key. And we take that writ of possession to the sheriffs. It's like delivering a key to the unit to the sheriffs. It's basically giving the sheriffs the authority to knock on the door and to remove the person either if they are removed, if they agree and they voluntarily walk out of the unit, or by force. If that happens in your case, or the best case scenario, the landlord's out of pocket is approximately $2,000, and the time to resolve the case, meaning from the time we serve the lawsuit until there's a lockout, is around 90 days. It can be 120 days, it can be 60 days, but that's a good faith estimate. The problem starts if the case is contested, meaning the tenant hires one of the extortionist law firms that they don't need to pay anything. They ask for a jury trial. They engage in delay tactics and abusive litigation. You're not going to like the process if that happens, because you're going to need to pay a lot of money to resolve the case. Most firms that know what they're doing will bill you hourly, and nobody wants to be billed hourly. I mean, I wouldn't want to pay an attorney hourly, even if it was a cheap hourly. So that's the nature of the game. You need to make sure you have the budget. You need to make sure that you have the evidence, because if you don't have the evidence, you're wasting money, right? If the tenant contests it and you can't prove that the person lived there, then how are you going to prove the case? Remember that in California, tenants can ask for a jury trial. It's becoming more and more common. Do you know who is contributing to the fact that jury demands are becoming more and more common? Mary? Shant?
I think it's our taxes.
doesn't
Yeah,
read my
you
emails
guys,
either.
you guys are contributing to it, right?
That's a good answer, but that's not what I was thinking. It's the court that needs to be neutral. And why is that? Because let's say that I'm the poor tenant, right? I'm a nuisance. I failed to pay rent. I have parties. I have an unauthorized occupant. The gentleman, the landlord, is evicting me. I go to the courthouse, to a self-help desk, and they tell me, "Oh, you need to file an answer." Well, I don't know what's an answer. Sir, you don't know what's an answer? No problem. Here it is. In that answer, the court already checks the box requesting a jury trial. So who's responsible for that? The court, that needs to be neutral. The tenant who is requesting the jury trial doesn't even know that they're requesting the jury trial, doesn't even know what it means to request a jury trial and how much burdensome it is on the tenant as well, because both parties need to prepare for that jury trial. And that's just one more indication of why this system is broken. To have the court, who needs to be kind of the middle entity and not take sides, to have the court give one of the parties their responsive pleading the answer, where all the defenses are checked, even though they don't apply, and a jury demand is made. It's a sad reality, unfortunately, right? Linda, she is a client of mine, and Linda had that. You had an attorney who asked for a jury trial, and we needed to bill you for that, even though I rather you pay the tenant to leave than pay our firm. But what they do is they delay. At some point, we need to start preparing for trial. The landlord incurs the cost, and right at the end, after 5, 6, 7 appearances, the attorney folded and we were able to settle the case. And that's 90% of the cases. That's how they resolve.